Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2022 Harlan Institute Ashbrook Virtual Supreme Court Competition. This year, we're mooting the case of Students for Fair Admission versus the University of North Carolina. This is a semifinal round, and we have match number 2, and we have Maeve Durkee and Diane Chowdhury from Creeview High School in Texas. And for the respondents, we have Emily Holstein and Samantha Jarquim from Lake Oswego High School in Oregon. Teams, you ready? Okay, very good. Petitioners, you may begin whenever you are.
May it please the court, my name is Maeve Durkee. Alongside my co-counsel, Diane Chowdhury, we represent the petitioner, Students for Fair Admissions.
In creating a racially discriminatory affirmative action program, UNC has violated the 14th Amendment. Additionally, the decision in Grutter v. Bollinger fosters an environment where such unconstitutional programs are common and must be overruled. To address our first point, Grutter does not properly apply strict scrutiny. Grutter improperly applies strict scrutiny by removing the burden of proof from the university and takes the law school at its word. While the court claims to apply strict scrutiny, they require neither compelling interest nor a narrowly tailored scheme. The court allows the pursuit of educational benefits of a diverse student body, both vague terms at best. This holding is at odds with decades of precedent that allow only a remedial interest in combating the effects of prior de jure segregation. Grutter also flouts all precedent in its supposed application of the narrowly tailored standard, allowing the university to use race where a race-neutral plan might work. The court also pays lip service to the idea of a 25-year time limit on racially discriminatory affirmative action, but leaves it to the university to regulate their own program. Additionally, even under Grutter, UNC's scheme is unconstitutional, as it both intends to exceed the 25-year time limit and employs the functional equivalent of a quota.
To address our second point, UNC's program fails strict scrutiny. Its supposed interest in campus diversity is vague and uncompelling, especially when contrasted with established compelling interests in remedying prior de jure discrimination. An interest in diversity is so broad it can't be proven to have any concrete benefits, and were it any more specific, it would constitute a quota. In the respondent's brief, they suggest that UNC's interest in diversity is similar to the interests of the Freedmen's Bureau during the process of Reconstruction. However, UNC has no remedial interest in affirmative action, simply an interest in the educational benefits that they can derive from the presence of minority students. Additionally,
Let's talk about that legislation for a bit you mentioned. So in your view, how does the Freedmen's Bureau Act affect our deliberations here?
Well, Your Honor, while the Freedmen's Bureau and, other acts that worked in tandem to create this sort of status of African Americans as true citizens of the United States in sort of the Reconstruction South, they certainly did use racially specific, legislation in some aspects. However, that was during an extremely different time. They were remedying these really heinous acts of Black codes, the legal endorsement of slavery, which really does not exist in any sort of way today. The government shouldn't interfere in sort of this more nebulous societal discrimination, whereas they did have a responsibility to interfere in when they had in fact created this discrimination.
Counselor, do you think there's any role for universities to consider race today?
No, Your Honor.
None.
Absolutely not.
If entering class was 100% white, not a single minority kid, that'd be okay?
Well, that would probably indicate some discrimination had taken place.
None.
They are
None. They follow the rules and the application. Whoever shows up, not a single African American student shows up. Not a single Hispanic kid shows up.
Well, Your Honor, that's certainly not what's happening today. But it might be a problem in, there probably is something wrong with their admissions. They might want to change it a little bit, but that's not what's happening today. The university
isn't that kind of what the universities are saying will happen today? These universities have said that they've tried or they implement race neutral as much as they can, and to get this diversity that they need, there needs to be at least some application to diversity. So can we truly say that that just wouldn't happen, to Judge Blackman's point, that if you were to take away these these racial identifiers, then that there couldn't be a possibility of having a zero diversity class?
Well, Your Honor, the universities are certainly claiming something of that nature, but that's not actually true. There are successful race-neutral schemes that use in Texas A&M, the University of Texas, Washington State, and the University of Washington, among others. There are absolutely race-neutral schemes which will allow for student body diversity. Even
Let's talk
Fisher,
about
which builds
concept-
upon Grutter's
let-
faulty application.
Let's go back to the history for a bit, though, right? Your brief makes a lot about, Plessy versus Ferguson and Justice Harlan's dissent. But can't Harlan be understood to say that when the government can provide a benefit to racial groups, racial minorities, they should? Can't you read those cases that way?
Maybe one could read those cases that way, but that's certainly not how those cases were intended. Your Honor, Justice Harlan advocates a colorblind constitution, not a constitution that sees race when it can benefit a minority group. The 14th Amendment is wholly racially neutral, and it's intended that way. To favor certain minority groups would be, racially discriminatory. It can create sort of racial animus on campuses where it may not otherwise exist, and it disadvantages people on the basis of race.
Let me ask a question for your partner to make sure we can balance the load a bit. Do you think that Brown prohibits any consideration of race in higher education, Brown versus Board of Education?
Yes. Brown prohibits any use of race in application for higher education, as Brown was intended to give everyone an equal chance in pursuing education. And at the time of Brown, it was about including African-American students into public schools. And now today, the case is very different, as back then we were remedying the effects of slavery, and today the effects aren't remedial and they're discriminatory against unfavored students and applications.
We'll now move on to
Counselor, if I may ask a question, your brief tends to suggest that maybe we are at a point or almost at the point where we're no longer having issues with legally recognized racial discrimination, meaning there are no longer laws that allow for this kind of discrimination. I think UNC would argue that while the laws may have changed, racial discrimination still exists in this country, and this discrimination impacts who can access a higher education. How do you respond to this argument?
We respond to this argument by there is still racial discrimination in this country. However, the effects are significantly lessened as they were a century ago. And now if universities were to use race to achieve a diverse student body, they would be trying to accomplish a critical mass, which is vague. And vagueness shows an interest and that is unquantified and cannot be met. As if there were 60% of this race, then that would be met. If there were 5%, they would not have met this a standard, and that means there's a quota.
But Counselor, aren't we kind of in a circular argument now where we know that quotas aren't allowed, correct? Like that's not an issue here. UNC and other universities do not meet quotas. And what I kind of just heard you say is, well, the way they do it is too vague. And, if they were to have a quota, that would make sense, but then that wouldn't be allowed either because quotas aren't allowed. So can you expand a little bit on if this is too vague, then what approach would be acceptable to you?
Well, Your Honor, what we are arguing is that they are using this sort of vague interest to obfuscate their use of a quota. They are truly using a quota in their pursuit of a critical mass of minority students. There is some number, which is a critical mass that they are.
If I may interject, isn't UNC looking at other factors besides race? How are you coming to the conclusion that the admissions process, that race is the sole factor that UNC used?
Well, Your Honor, while the race might not be the sole factor in all admissions, there are some admissions necessarily where race is the factor that means an applicant will be admitted. That's, affirmative action wouldn't work if that weren't true. To address the third point,
To address our third point, the dissolution of racially discriminatory affirmative action programs is the natural extension of the cultural and judicial trend away from racial classification. Even in the respondents' own brief, they acknowledge that since education has become desegregated, the court has continually narrowed how institutes of education can evaluate race as a factor in admissions. The doctrine of racial classification has evolved past Plessy and into Brown, the Brown's colorblind trend, a trend that should be followed in all cases about racial classification. Although the 14th Amendment was not always so strictly interpreted, it is the court's responsibility to enforce the true doctrine of complete rejection of discrimination.
Okay.
It is
Thank
for these reasons, sorry. It is for these reasons we pray that the court overturn the lower court's ruling and rule in favor of the petitioner, students for fair admissions. Thank you.
Thank you so much, Counselor. If the respondents please come back on camera, you have 15 minutes.
My name is Emily Holstein, and alongside with my co-counsel Samantha Hakeem, and we represent the respondents, the University of North Carolina and students. May it please the court.
Sparked by Students for Fair Admission claiming that a white member was denied admission to the freshman class of 2014 due to the affirmative action policies at University of North Carolina, this case asks the court to apply the 14th Amendment's guarantee of racial neutrality to public colleges as well as private colleges.
Race-conscious affirmative action is consistent with the 14th Amendment for three reasons. Firstly, the court's precedent supports the respondent. Second, universities have a compelling state interest in a higher education that affirmative action supports. Third, Grutter v. Bullinger does not meet the requirements to be overturned.
Firstly, this court's precedent supports the respondent. Grutter v. Bullinger does not contradict the limitation of affirmative action established in the University of California v. Bakke that says that a fixed quota system for racial groups is unconstitutional. Not only does UNC stay within the limitations, race is one of 40 other factors considered in this holistic admission process. Considering that Fisher v. University of Texas Austin states that affirmative action is appropriately narrowly tailored if race is used as one of many factors to pursue diversity, USC is exceptionally within the limits and excitations of the use of affirmative action.
Secondly, Grutter v. Bullinger establishes that affirmative action is constitutional under the expectations that universities will uphold that such practice to further a compelling state interest. Explicitly making diversity in education benefits a compelling state interest because additionally, when the state of California banned affirmative action, diversity in classrooms consequently decreased, as we saw in Proposition 290.
Thirdly, Grutter v. Bullinger does not meet the criteria to be overturned. Established in Dobbs v. Jackson, there are 5 criteria that are considered when overturning a case. Firstly, previous rulings must have an error, meaning that the court previously wrongly interpreted.
If I could jump in, so I appreciate the discussion whether the previous rule was an error. Let's talk about Justice Harlan's dissent in Plessy v. Ferguson. How do you think that impacts our case here?
Well, that was clearly a reflection of the cultural importance, the culture that was going on within that time.
What did Harlan say in his Plessy dissent? Can you tell me, please?
Your Honor, I'm not sure.
Okay, go on. Well, do you remember what Plessy v. Ferguson was about?
Yeah, separate but not equal.
Okay.
Separate but equal.
Right.
Yeah, that's what I
Well, that case involved segregated rail cars, and Justice Harlan said our Constitution is colorblind. What does that mean to you to have a colorblind Constitution?
We don't see color when we're kind of taking into account like different institutions or opportunities in life, and instead evaluate other things instead.
Okay, may continue.
All right, so the previous ruling must have an error, meaning that the court previously wrongly interpreted the case or had some sort of misjudgment. And the second criteria is that the quality of reasoning must be poor. We believe that these two are not satisfied because the Grutter follows a clear line of reasoning and is backed up by President Bakke, Gratz, and Fisher v. University of Texas. It follows a general trend where the court applies limitations but does allow affirmative action. Thirdly, the case should exhibit workability. The ability to understand and apply precedent of the case
If I can interrupt, Grutter Grutter seems to suggest that it was limited, right? Justice O'Connor said there's a 25-year clock, and we're coming up on that awfully soon.
Yes.
Has Grutter proven workable?
We believe yes, because it reiterates that in suspect classification, there needs to be both a compelling interest and a narrowly tailored policy. We already know that a narrowly tailored policy needs to be a policy in which no other alternative could serve its intended purpose, and it cannot be a mechanized system. And a compelling state interest can be diversity in higher education for the benefits of the whole student body. So we believe that these requirements can be
To go back to the workable issue, your colleagues on the other side talked about how this is a very vague standard. It allows universities to do more or less do what they want and have these kind of pseudo quotas that they call something else. So is that workable? This kind of vague standard of just letting universities do what they want? Would you consider that a workable standard under the previous decisions?
Yeah, the affirmative action is just is a way for schools to ensure that there is diversity in classrooms, and that students have the highest education possible. And what better people to decide what is the best education for its students than the university itself. And it's not exactly letting the universities do whatever they please. I mean, affirmative action is a very controversial subject, and if universities take it too far, then the courts will definitely restrict upon affirmative action.
And we already know that we can't use.
Counsel, excuse me. Petitioner argues that UNC's admission process is not narrowly tailored enough because UNC has rejected other race neutral schemes. How do you respond to that?
Well, as we know, race is considered one of 40 other factors, and it is not a deciding factor. So we believe that there is, I'm sorry.
Well, the other workable alternatives aren't really alternatives for that would uphold what the school is trying to obtain, which is the highest education for their students possible. When in Proposition 290, when the state of California took away affirmative action, we saw that test scores and freshman year GPAs consequently decreased, and that does not satisfy the university's main goal, which is to educate its students.
And to add on to Emily's point, we have seen in recent years, as recent as 2016, there has been less than a 10% Black enrollment at UNC, which means even with affirmative action, there is still not great diversity at the University of North Carolina.
Which is to say that affirmative action is not handing off spots to people of color. It's who is the best applicant, and their race is just a plus factor in the holistic admissions process.
So would it be fair to say that UNC only appreciates certain kinds of diversity in its application process? And what I mean by this is on the application, there is a checkbox for what race the applicant is, but there's no checkbox for what religion the applicant is or student or what political affiliation a student may be interested in. If UNC's goal is to have a diverse student body, is diversity only accomplished by the race of its students?
No, with people of different backgrounds, people are already diverse enough even without race. And these different classifications don't fall under suspect classifications. So we would need a different way to address diversity with intermediate and different classifications.
I think Justice Nielsen's asking a slightly different question. If you're so interested in diversity, why aren't you asking about their religion?
Well, because things like religion and political beliefs are a lot more convoluted than races.
Really? Race is simple?
No.
Maybe think about that one more time.
Just the fact that that they're that someone who is that it's possible for someone to be for a whole kind of class of someone to be all white or all Black or something like that, where in that you would see completely varying political opinions. Like in my family, my entire family is white, but we all have somewhat different political beliefs and religious beliefs.
But counsel, I mean, I would push back on that a little bit because, we're talking about a selection process. And quite frankly, a selection process could be geared towards having only people of one political preference or only one religion. You could do that just as easily as anything else. And so I would push back a little bit on that line of reasoning for how it differs. Would you have a response to that?
Well, I believe that political affiliations and religion don't hinder and limit the opportunities the same way that race does. And there can still be diversity of political affiliations, religions, and other identities within a race.
Then why does UNC's application need the race checkbox? Couldn't this information be relayed in, say, the essay? Because your brief talks a lot about the importance of identity. And I believe that is important, but why does it have to be a checkbox? Why can't that information be included in other parts of the application?
Because people are very complicated, and for one person, when you're admitting people and you people who are of color have multiple identities, their race is not their only identity that they're kind of required to talk about. It might be easier or kind of kinder for them to be able to write an essay on why they love soccer.
But then to Justice Nielsen's question, why do you need the checkbox? If this is such a complicated concept, wouldn't an essay or some free form prompt be better than, check 1, 2, 3?
Well, if let's say a Black student were being admitted on for not academic but sports, and they were going to play on their soccer team, they might prefer to write their essay about soccer instead of their race.
Good. I'm not arguing against the essay. I'm arguing against the checkbox. Why do you need in other words, why do you still need the checkbox?
I think it's a simple way to classify people because college admissions don't have a lot of time to go through applicants, and they may not be able to.
The problem that you're classifying people based on their race is not about holistic. It's you're classifying them based on what box they check.
Well, the nature of checking a box is very small. It's a very small thing, and it kind of gives away that it's just one part of the entire admissions process. They're just going to see one little box and then keep going with their entire essay and all of their extracurriculars and their GPA.
But yes, I hear what you're saying, but it seems like the checkbox is just an easy administrative way for UNC to sort students by race. So why is that important? Why is that a compelling interest that we do that?
Diversity as we saw in diversity is a compelling state interest because it creates a higher education. People coming from all different backgrounds and different life experiences and different races. It combats racism, and to learn an environment with completely different types of people from different backgrounds, it reinforces the highest education that a student can get.
Counselor, let me ask you a question. When will you have enough diversity that you won't need affirmative action anymore?
Well, right now, as we see with poverty and people of color mainly being subjected to that, people of color are not given, for the most part, the same opportunity.
You keep saying people of color. Which minority groups are covered by that?
Hispanics, Black people, people of color, Native Americans.
Asian Americans, are they covered?
Yeah.
So UNC doesn't provide racial preferences for Asian Americans. In fact, the arguments are quite the opposite, that they are harmed by the admission policies. Why are they not people of color?
They are, but as we see mainly in colleges, that generally Asian Americans do better and do have more opportunities than, say, a Black person when looking at tutoring or better schools generally.
So you're not saying that the fact that they're people of color is that they're societally depressed or economically underprivileged? Is that what you're saying?
It's for diversity, and so I would.
But then why not benefit for Asian Americans? You're saying because they do better. Okay, I'll accept that position. I mean, it seems what you're saying is you want to help people who are worse off in society, not just because of their skin color. Is that what you're saying?
we have seen that in California, where there was a ban on affirmative action, Asian Americans were able to achieve this relatively same success before and after affirmative action. So we believe that
And if you took away affirmative action and say a university was just filled with Asian Americans and white people, then that wouldn't really be obtaining a diverse learning environment, which wouldn't be
Well,
creating.
counsel, the last couple of minutes of your interaction with Justice Blackman, you seem to kind of switch to this idea of, well, those economic factors and different things. And I would agree that there are historical economic disparities amongst different groups of people. But doesn't that kind of go back to those race neutral ways that this can be addressed, that they can look at these things and focus on programs that focuses on economic deficiencies and stuff to give bonuses, and that would be a race neutral way of doing it?
Well, the court's past precedent has upheld that affirmative action is a good way and a satisfactory way of satisfying the compelling state interests of a diverse learning environment, while not infringing on the 14th Amendment.
All right, counsel, I see your time's up. If the petitioners please come on, you have your rebuttal time, please. Okay, 5 minutes whenever you're ready to begin. Whenever you're ready.
May it please the court. My name is Don Chaudhary, and alongside my co-counsel Maeve Durkee, will be rebutting the respondent's argument in 4 points.
To address our first point, respondents fail to prove that the university unconstitutionally regulated axes such as socioeconomic status. Opposing counsel claims that applicants are diverse enough in religion and other factors and that they don't need to address it. But UNC has an almost entirely upper class enrollment, with a median income almost triple that of the nation's median income. Their affirmative action program suggests an unconstitutional preoccupation with race, fuels their interest in an affirmative action program, rather than any true interest in diversity. The racially discriminatory scheme fails Justice Harlan's seminal vision of a colorblind constitution by affording applicants benefits based exclusively on race.
To address our second point, UNC's race of critical mass is clearly an obfuscated use of a quota, failing strict scrutiny. Any proponents of UNC's scheme would agree that a 5% enrollment of minority beings would not constitute a critical mass, and 60% would likely exceed it.
Counsel, if we are to rule in your favor today, what rule do you think this court should come up with? Are we saying that a diverse student body should no longer be considered a compelling interest? Is that what you want?
Yes, Your Honor. The only compelling interest permissible to allow this invidious classification of race into our federal, or our laws would be the remedial interest triggered by some sort of de jure segregation against
North
any sort
Carolina,
of-
I mean, if I can interrupt you, counsel, North Carolina has a history of segregation, don't they? This was not a pleasant state for Black students 70 years ago. Maybe this is remedial.
Your Honor, it's maybe 70 years ago it would have been remedial, but as of current day, it is less remedial and more favoring them, which is discriminatory against applicants that aren't favored in college admissions, meaning it is unconstitutional.
Additionally, UNC states no remedial interest. Their interest is in the educational benefits they can derive from diversity, not any sort of benefits to these African American and Hispanic students.
There is and to go back to my point I was addressing earlier, if they were to have 5% of a minority student body, that would be too little, 60% would be too much. There's a percentage that the affirmative action program is aiming for and will have failed in its goal should it not hit that percentage, the textbook definition of a quota, rendering UNC's program unconstitutional even under Gruddy.
To address our third point.
Justice Nielsen, go ahead. Justice
Yeah.
Nielsen, go ahead.
Can the admissions process ever be truly raceless? Even if we remove the checkbox for an applicant to select their race, can't the university still use race as a factor, but maybe not so explicitly? And how do we look out for that? How do we analyze whether or not a university is unconstitutionally using race as part of the admissions process?
Well, Your Honor, if they are using race itself to determine whether or not an applicant will be admitted. However, they could use some sort of supplemental essay that described students' experiences with race and racism, but that essay would not be affording them
counsel,
the
Aren't we just back to the same place now? Aren't we just back to the same place with extra steps, Willie? I mean, if the university is going to use anything, essay, anything that is about, race or about what race played in the world of college. And I'm not saying that's good or bad. I'm saying, isn't that just back to schools are now, using race as a determining factor? Which is
no,
what it
Your
again.
no, Your Honor, because those essays would deal with, students' perseverance, students' ability to, become education, persevere through educational and difficulties.
Why are those things
or-
important? Why is perseverance important?
Well, especially in law school, there, Your Honor, there is a lot of classes. It's a difficult journey,
It is.
similar to the sort of difficult journeys that these applicants will have experienced. They're showing their capability to succeed in law school, not their race. To address our third point, fundamentally, UNC's program discriminates against applicants, no matter how opposing counsel tries to whitewash their intentions. When a member of a non-favored group and applies and is rejected, that applicant is being discriminated on the basis of race. And then to address our fourth point, this court has responsibility to overrule Grutter and its accompanying cases under Dobbs. Like Roe, Grutter was egregiously wrong from the start. Its reasoning was exceptionally weak, and that this decision has had damaging consequences. The 5 areas of concern established in Dobbs all confirm the necessity of overturning Grutter, and Grutter is very like the Roe v. Wade ruling, in that they are both improper. Can I finish the paragraph?
Yes.
Improper interpretations of precedent with no basis in either history or the text of the Constitution. And like in the Dobbs case, in today's case, this court has the duty to properly apply the law, no matter what popular opinion might dictate.
It is for these reasons we pray that this court rules in favor of the petitioners and overturn the lower.
Okay, thank you so much. All right, the case is submitted. Please, if the respondents come back on camera, petitioners on camera, please. Let me say first off, congratulations. This was very strong round. I have to remind myself that you're in high school, you're not law students. Maeve said a moment ago that law school is hard. Yeah, it's hard. These are 2 of my students who were grueling in my classes for a semester. And I think they'll tell you also that law school is hard, but you persevered. You persevered and you stuck to it. And I want to say congratulations. The level of poise and professionalism you bring is beyond your years. You don't even know it yet. But what you're doing here is why people in their mid-20s are pulling off in law school. I'll give some specific feedback, but I want to ask Kevin and Kathleen if they have any comments you want to give from the perspective of students.
Absolutely. I'll go first. I'll be you guys did y'all all did fantastic jobs. To echo a lot of what Professor Blackman said, it is hard. That was a great way to finish your run, because law school is not easy, and half the time you don't. And being able to be posed and work through the logic the best you can is a big part of it. And y'all both did that really well. You guys will ask questions that you obviously didn't know the answer to, which will happen more often than you'd like. And you did exactly what you needed to do, which was kind of work through your logic of it and answer it, to your best of your ability. And this is not an easy, this is not an easy subject. This is a subject that this is back in the Supreme Court for, round 10, if you count all the different, iterations of it. And so to, go through this as high school students, y'all did a very good job, and I'm very impressed.
Yeah, I'll piggyback off Kevin too. I was very impressed at all of your abilities to answer questions to the best of your ability, but then pivot to the points you wanted to address, which I think you all did a great job at that. And yeah, I will echo, I struggle a lot with oral arguments. It's so hard. Professor Blackman can attest to this. So I congratulate you on this. It's a really great, you guys did a great job, and I look forward to hearing all about you in law school.
Yeah, let me give you some particular feedback. What makes this case so hard is that you have arguments based on history, and you have arguments based on modern stuff, right? Stuff that's going on now. And in some regards, the respondents can lean on that history, right? And in other regards, the petitioners can lean on the modern stuff. So I think you both did well. So I'll start with the respondents. we were pushing you very hard to say, when is diversity enough? And you wouldn't budge on that line. We also asked you at the checkbox, which I think is a very difficult question that Kathleen put forward. And I think you got tripped up a little bit on that one, because when you pivot to the essay, you say, well, why can't you just have an essay? I think at one point you said that religion is not complicated, but race is. Oh man, I was like, uh-oh. Yeah, so I kind of jumped, but I know what you're getting at, and I think you recovered from that one nicely. You also had questions about socioeconomic. That's what Kevin was asking as well, and that's a tricky part. You also handled the question of the Asian Americans, I think, pretty well. It's not an easy point. If you actually listen to the actual Supreme Court argument, the question with the Asian Americans did not go over well with them. On the other side, with Maeve and Diane, a little bit more of a balance between the two teams. I think you're both strong advocates, but I think Maeve just talked a little bit more. There's nothing wrong with that, but we try to have it just balanced a little bit evenly, and I think that's something you can practice on for the future. Also, I think a few points you were sort of reading for your notes, which is fine, but as you go along the rounds, there should be less reading. Unless there's like a specific like quote from a case you want to bring up, you should have at least you can paraphrase. We don't need the verbatim quotation. And as the rounds advance, you'll see we give you much less time to speak. There's a lot more interruptions. I was kind of generous today, just kind of sitting back in my chair, letting things go on, but there's more interruptions. I think your rebuttal is also effective because I asked them about Plessy, they weren't sure, then you lit off with Plessy, which I think was actually very effective. I think that's all I have. Kathleen or Kevin, did I miss anything? Anything you want to add just to constructive feedback for the students?
Yeah, just the one last thing, just constructive feedback and criticism is both me and Kathleen did a lot of advocacy in law school, a lot like what y'all just did. Look, and I just did one. It's a great example because I just did it when I said, work on your tics, identify what your tic is when you're nervous and just try to limit it. I heard a couple, you knows, and, I believes. And again, as beginning students, you guys did amazing, but that's something that will get the right judge to jump down your throat on. So just as ways to just improve your delivery, there's just things to think about. You'll cringe a little bit when you do it, but always watch recordings of this and learn. I watch recordings of myself doing advocacy constantly, and it makes me kind of embarrassed for myself as I watch it, but it's a great way to build. So again, just fantastic job.
Yeah, and I will also say that I think you all did a great job keeping a cool temperament, because it can be quite hard when you're in the hot seat and you have all these questions at you and you feel like the judge is not on your side. So I congratulate you all on just keeping a cool temperament and just responding to the questions in a neutral tone.
Very good. Do you have questions from us? We're happy to take whatever questions you have, what's on your mind. And by the way, law school is difficult. This is exactly what you sort of get your first year of law school, and professor calls on you and you don't know what the heck the answer is to the question. You have to sort of deal with it. It's not, I do it every day. It's not a pleasant experience.
Do you all want to go to law school, I'm assuming?
Oh, wow. I think lots of nods. That's good. Well, if you're ever in Houston, you're welcome to come sit in my class, open offer whenever you want. You guys are in Dallas, a little bit closer, but the ones in Oregon maybe a little bit further of a drive.
I had sort of a question about how do you decide what law school you want to go to? What are really the major considerations you want to be thinking about?
Let me ask Kevin and Kathleen. They're closer to that decision. They have very different paths.
Yeah, I mean, yeah, I'm not a traditional law student in any regard. This is my second career. So for me, my considerations were a lot different than probably someone coming out of undergrad. I would think out of undergrad, you would look to see if the school had they taught the subjects you were interested in. That would be a big consideration. See if there's certain professor, because a lot of professors, they're in the media, they're in the news. That would be a consideration for me. What kind of student groups, what does the student body look like? Those would be, I would think, considerations out of undergraduate, and location too.
And I would just look at everything. It's real easy to get kind of tied up with rankings and different things. And you've probably seen some of the news that people are mixing up about what they think about rankings. But there's a lot of things that schools specialize in. Do you want to be a litigator? Do you want to be more of a transactional type lawyer. I was a spring start. South Texas here in Houston is one of the few schools in the country that allows me to start in the spring. A full section started off cycle really. And that was something that was important to me. So it's one of those kind of just holistic approach to look at just kind of everything and, and make that, best decision. And the advice I got that I still think was good advice is location is important, something that Kathleen just kind of ended on. It's a big leg up in a lot of circumstances. If you go to a law school that's kind of in the region or the state or the area you think you want to practice. I mean, there's caveats to that, of course. You go to some of the, really top law schools, you can go anywhere you want, I'm sure. But I think that is a factor that can be helpful as well as you make that decision.
Yeah, another decision's money. I don't want to make too light of that,
Yeah.
but law schools do get financial aid based on both need and also merit. And it's possible that if your LSAT score and GPA are very high, you could perhaps go to a school that's a slightly lower ranking and they give you more money for it. And there's nothing wrong with that. Graduating without debt lets you consider different career paths that you would not otherwise be able to do. You may not be as inclined to go into big law and actually I think Kathleen's clerking for a judge and then Kevin's also clerking for a judge when they graduate. But the ability to do that means they're gonna have a lot of debt they have to pay off if they have to have a lower salary. So
Thanks for reminding me.
I'm sorry. It took me a decade to pay off my student loans. A decade after I graduated law school to pay off all my loans. I finished it. It was all done. But financial incentives also matters. Also, a general rule, if you plan to go to law school in a place, you should plan on actually working in that community. I mean, the internships, the networks, the jobs you find in that area will probably stay with you. So if you go to law school somewhere, that's probably going to make your career. I mean, people can move around, New York, Washington, LA, of course, but there's a value there.
Yeah, and I was going to say, to go off of that, where I work at the public defender's office in Houston, and we have applicants from all over the country from top law schools, and the employer here the chief public defender here wants people that are invested in the community and have been invested in the community, regardless of they went to Harvard Law or South Texas. So I would definitely consider, when you're considering what you want to do, like thinking about that too, because a lot of employers are starting to regionally in the region they're in, think about those things.
And then I had a question about how late do you specialize? I have an interest in social justice and social justice work, but I don't is that civil? Is that criminal? Is it appellate?
You have no idea what you want to do.
Yeah.
I went to law school for intellectual property stuff and I love constitutional law. You have no idea what you want to do.
Okay.
And it's going to change too.
You don't major. Law school is not like a college. You have a major. You can specialize. That's not really a thing. You just take more classes, maybe a certificate or something.
Okay.
Suffer through 4 years of college first. You may not want to do law school anymore. And then you suffer through the first year of law school, then you'll know what you want to do. Or maybe the second year of law school. So go in there with an eyes wide open. You really there's so many opportunities you can do. So many different things you can do. What about our friends from Oregon? Any questions?
Just what would you say is the most important thing that you could do in your undergrad to kind of prepare for law school, if anything?
Write. Learn to write. Writing is very important, right? You can take an LSAT class and cram for it. GPAs vary because if you're not good, we'll be honest here. There's some majors with easier GPAs than others. If you're in a hard science major, your GPA is going to suck, right? If you're in a liberal arts major, it's a little bit easier to have a high GPA. That's just a fact of life. But one of the most important skills you can bring to law school is the ability to write well. Take classes in writing, technical writing, creative writing, everything. If you only know how to answer a multiple choice exam, you're going to not do well. You have to be able to write. I don't know, Kathleen and Kevin, you're closer to this. What are your thoughts?
Yeah, I would say for me, the most important thing that I learned in law school that I wish I would have learned a little earlier is how to manage stress better in law school, because undergraduate program, and I have my master's too, both of those programs I could manage my stress really easy. Law school is a lot different. So it took me a while, during 1L to figure out how to manage my stress better and manage the workload. So creating that system for yourself earlier on before you go to law school, I think would be super helpful.
Yeah, I'm probably not the one to ask. I went to undergraduate with a completely different plan and decided to go to law school kind of on a whim after I graduated with a hard science degree, like Professor Blackman was just talking about. But I think what it can do is just it can help you be prepared. You know, take meaningful classes. Don't take beer appreciation or whatever I did my last semester of University of Houston. Take stuff that will challenge you, because law school will be challenging. And for a lot of people, law school is kind of the first time that you're not the smartest person in the room for a lot of students. Most people that go to law school have always been the top 10%. You know, they've been the top 10% of the high school. They graduate top 10%. And generally law school is the first time where everybody in the room was in that top 5, top 10% of whatever they've done in life. And I think taking hard classes and taking classes in undergraduate that challenges you and teaches you to think will really help you when you are in that situation where you might not be the smartest person in the room like you're probably accustomed to, like most people that go to law school.
I don't know, and I'm also a big advocate for working after undergrad for a year or two at least before going to law school, because there's a lot you learn, just no matter what job it is, just like learning from your colleagues and your boss and your mentors. So I'm an advocate for not going right to law school from undergrad, but that's just me.
I did. What do I know? What else? What other questions do you have? Maybe about the round itself? Any thoughts on the competition?
I was wondering what you thought of the Dobbs argument. Like
Well, Dobbs is
stare
important
decisis.
because for stare
Okay.
decisis, this is your precedent. This is what you have to talk about. So I think that was absolutely fair game.
Okay.
I think petitioners have to say, yes, it's egregious, just like Roe v. Wade, and the other side says, no, there's reliance interest. People go to colleges, universities, establish their admissions policies. It's different than abortion. But I think you have to both argue both sides of that case.
And I think you did it well. That kind of argument is sometimes you'll hear it referred to as a lightning rod type thing, where you may be opening the door to a conversation you don't want to have with judges. And that's common when you have an argument that, you know that this is a hot topic. If I say this, I may be jumped with questions kind of thing. But I think you handled it well because like Professor Blackman said, I think it's something worth acknowledging in your arguments.
All right. Anything else? All right. Well, if I can ask the students to sign off, I'll talk to the judges for a bit. We'll put your grades in, but wish you all the best of luck. And you know to reach me, Josh Blackman. You can email me for any questions. If you're in Houston, come on by my class. Happy to have you visit. Thank you so much.
Thank you. Thank you.
All right. Let's turn off the recording.